Hello and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law. And today we have a great topic. Today's topic is going to be congratulations, you're turning 18. This podcast is going to be directed to the young individuals who are turning 18 years old, congratulations. Or to the parents or grandparents of an individual who may be turning 18 in the near future or who recently has. It's always a great time of year when it's high school graduation. Kids are getting ready to go off to the military or getting ready to maybe head off to college or enter the workforce. And I just want to make sure that everybody understands some things that are automatically assumed when a person turns 18. Now, as always, I just want to do a quick disclaimer. Please do not take legal advice from this radio show or any other radio show for that matter. If you're looking for legal advice specific to your situation and to your family, please reach out to an attorney licensed in the state that you are in and who practices in the area that you are looking for. Only they can give you legal advice specific to your situation that will be able to assist you and your family. This radio show and every other radio show is for informational and educational purposes only. It is to get you thinking so that you can then reach out to someone who can give you legal advice. If you happen to be in the state of Pennsylvania, in the York, Lancaster areas, or anywhere in the state looking for legal advice in the estate planning and elder law arena, Belomo & Associates would be honored to assist you. You can find us at 717-845-5390 or on the web at www.belomoassociates.com. We would be honored to assist you. We offer free educational workshops on a weekly basis in the estate planning arena, as well as in the crisis Medicaid and special needs, as well as probate administration and trust administration. If it's a topic related to estate planning and elder law, we most likely have a workshop for you. And almost all of our workshops are available via a link that you can watch from the comfort of your home or live Zoom from the live event that we are hosting in our local offices. We would be honored to have you attend one of our workshops and to be able to assist you and your family with their legal needs. All right, well, let's talk today on our podcast. So when an individual turns 18, what does that mean? Well, the law presumes that they now are of the age of majority, which means they have legal capacity to enter into contracts, to vote, to enter the military, right? They have all of these rights immediately when they turn 18. They can get married, right? They can do all kinds of wonderful things. Now, let's remember, they still can't drink and they still can't rent a car in most states. But hey, they certainly have a lot of opportunities and things that they couldn't do when they were 17 years old. So what does that mean? Well, that means when you turn 18, you are deemed to be an adult. You now get to make decisions for yourself, and your parents no longer can make them for you. Now, why is that significant? Well, for a lot of reasons, frankly. But what happens in a lot of cases is that parents just assume that they can continue to make decisions for their 18-year-old or 19, 20-year-old. And the truth is that is not the law. The law says when you turn 18, you now are on your own and you are an adult. So what does that mean in real life? Well, let's say a kid goes off to college and maybe they're struggling with grades, or maybe there's an issue with their tuition package, or maybe they need to move money and the bank is giving them an issue. Well, once they're 18, you better have a financial power of attorney in place to authorize somebody, and presumably the parents, in order to be able to continue to help them, continue to make decisions. Individuals go off into the workforce. Maybe there's an issue with the employer, or maybe there's still an issue with the bank. Same rules apply. Maybe you're in the military and you're overseas. Who's going to make those decisions for you? And please don't assume that it's the parent. It is not. It will not be the parent once they're 18. A financial power of attorney allows and authorizes the parents or whoever the individuals pick to be the financial power, to write bills, to contact the bank, to be able to assist with other just day-to-day matters. Maybe there is an issue that they need to call the school and check in on the financial aid package. Now, even if you're paying for the tuition bill, that does not mean that you're going to be able to call the school and talk about the grades, right? That is not the case. Well, let's talk about healthcare. That also is the same rule on the healthcare side. Now, the problem is many people just assume that they can call the hospital or they can show up at the hospital and it's their child. And in some states, there definitely is healthcare statutes that will allow that to occur. But again, let's not take that chance. Let's not take the chance of allowing someone to show up at a hospital and not have someone authorized. A lot of people get very complacent because they say, well, hey, Jeff, I'm pretty confident based upon what my doctor said that, in Pennsylvania, there's a healthcare statute and it allows the parents to make decisions. So I'm not going to waste my time in getting a healthcare power of attorney. Well, here's the problem with that. Individuals travel, right? Children love to go away for spring break or for trips with their friends. And oftentimes they don't go to school in the same state that you reside in. They go all over the country, or they're traveling, or they're sightseeing, or they're visiting their friends in different places. Not all states mirror certain laws of other states. So right out of the gate, my answer to those people is you cannot rely on a rule that you believe says something that it says. And also, a lot of times, depending on the trauma or the issue that is occurring, individuals will be taken out of state to go to a specialty hospital or to go to a much bigger hospital that can handle different types of trauma. So my advice, make sure that you are getting that healthcare power of attorney in place with the HIPAA language in it. That is going to allow an individual to be able to make decisions for the medical side for someone who is over the age of 18. Now you don't have to worry about what state. You don't have to worry about the laws of where you are and whether it actually says that the parent can make those healthcare decisions. They're 18. They are presumed to be an adult. But if they can't make a decision for themselves, whether it be financial or medical, the only alternative at that point would be to go to a guardianship hearing. Now, I know I've discussed this on other podcasts, but I have to tell you, I believe guardianships are a wonderful necessity that definitely have a place and definitely are needed in certain circumstances. But it is not a pleasant process. It is not for the faint of heart. It is certainly a very emotional, draining, overwhelming time. Now let's envision this. Here we are, our child is off in the workforce, in the military, or at school, at college, or at a trade school, wherever they are, and they have a major healthcare issue, right? So now, or a financial problem, and there's not a financial POA. They can't talk to the bank. They can't talk to the work employer or to the school. So now we're forced to get a guardianship. Well, what does that mean? What that means is that the parent of a child who just turned 18, who the parent is so used to making decisions, helping, being there, being relied on, now has to file a petition in the court, which is called a guardianship petition, alleging that their son, daughter, whomever, is no longer able to make decisions for themselves, right? So now they're filing a legal petition, most presumably with a lawyer, right? Because they're not going to know how to file a petition. So they're going to hire a lawyer. And what the petition is going to say is our son or daughter or our child can no longer make decisions for themselves. Even though they're 18, even though they're deemed to have capacity, they are not able to in this situation. They are a detriment to themselves or to society. They are not able to act in their best interest for physical safety or health safety. and now someone has to be named guardian. The parent, presumably, would be the guardian over the individual, which essentially will take things back to how it was when they were a minor. But the significance of this is that now you have a legal adult who has to be brought into a room and read the petition, essentially saying your parents are filing a petition in the Court of Common Pleas in York County or whatever county you're in, alleging that you no longer have capacity. A guardian needs to be appointed for you in their mind, and that they think they should be the guardian. A hearing will be held on such and such a date in such and such a courtroom in the Court of Common Pleas in York County. If you cannot afford a lawyer, one will be appointed for you. Blah, 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 right? Now, very often, individuals who maybe don't have the ability to make the decisions for themselves, maybe they don't have capacity, but oftentimes they understand something is going on and they don't like it. And the example I give all the time is I did a guardianship hearing for a husband and wife who were married for 45 years. And all the wife could say is, we were married for 45 years. This is the thank you I get? You ought to be ashamed of yourself. No, she did not have capacity. No, she was not able to make decisions for herself. But imagine the stress on the spouse having to make that decision. It would be the same for a parent. It would be the same for a parent who gets that dreaded phone call at 3 a.m. and has to rush to wherever their child is having issues, and then has to file a guardianship hearing to take away their child's rights to make decisions for themselves. All of that can be avoided by having a financial power and medical power in place. And in the medical power, you want the HIPAA language embedded in there so that the doctors and healthcare professionals can still talk to the parents or whoever it is that's being named as the power of attorney. And those simple documents will avoid or eliminate the need to ever have to go to a guardianship hearing. So that's a simple thing that can be taken care of. One of the jokes that I always make in my networking groups is, nothing says love and happy graduation like a power of attorney, financial and medical, so that your children can go off into life knowing that they can still get assistance from their parents. Now, it always gets a chuckle, but I'm not trying to be funny. It is one of the most important things that you can do for a child or an individual so that they have the ability for others to make decisions for them. We all end up getting to a point where we lack capacity. Oftentimes it happens because of an accident, because of a stroke, because of a car accident, because of things outside of our control. And yes, sometimes it does happen to individuals who are 18 years old, 19, 20, 21. It is not just something that happens to older adults. Now, I also want to address one other thing that is often embedded in medical powers of attorney. If a medical power of attorney has a living will in it, that is called an advanced healthcare directive. And in that document, it will provide for the ability for the individual to make a decision about what happens if and when they become what is called end-stage medical. Essentially, and I'm just paraphrasing the statute because it's a very long statute and a little confusing, so I'll just put it into terms that I understand, and that is, if two qualified physicians put in writing that the individual doesn't have any realistic hope of recovery, they will always remain vegetative, comatose, permanently unconscious, terminally ill, and that there is no realistic hope of recovery. They are only alive because of the machines or because of heroic and life-saving measures that are keeping them alive. If we withdrew those measures, they would then not be able to live a life because they would be permanently unconscious, vegetative, comatose, terminally ill. So here's the significance of this. The individual themselves gets to make the decision as to what they want to have happen. Now, when you're over 18, you are again presumed to have capacity to make decisions, to be the individual that gets to make that call. Now, I know a lot of parents want to say, my child is too young, even 25-year-olds, 30-year-olds, They're too young to understand the gravity of that decision. And I disagree. I think that we are, especially this day and age, introducing and allowing children and adults to be part of those, seeing grandma and grandpa, maybe seeing mom and dad in the hospitals and having those conversations. And if we're not, we should be. We need to be having that so that we understand what it is that the individual would want in that situation. Now, we did have a really horrific case where it was fairly known by everybody that the child would not have wanted, no, by child, I mean over 18. In fact, that individual was probably 28 or 30 years old. But same concept where there were conversations with family members and with friends. And he did watch older grandparents and individuals going through difficult situations, visiting them in the hospital, visiting them in the nursing home, and had said to numerous people, man, I don't want to live like that. I don't want to live in a situation where I can't have a normal quality of life. I don't want a situation where individuals have to come see me and cry because I can't communicate and I don't understand that I'm not there. I may be there physically, but I'm not there mentally. I would never want to do that to myself or to my family. And I wouldn't even want people to see me that way. That is not how I would want people to see me. Now, the individual did not have any planning in place. And one thing led to another. And next thing we know, he's in the hospital and was definitely brain dead. And it was very clear. The doctors immediately assessed after a pretty quick assessment that unfortunately he would never live a life. He would never be able to communicate. He would never be able to have conversations. He would never be able to move, get up, live a life. Essentially, at that point, he was vegetative, comatose, and would never, ever be able to have a life of just normalcy and being able to get up or do anything or communicate. And the problem is everybody around him knew what he wanted. Everybody around him knew and had had conversations about the fact that he would not want heroic and life-saving measures, that he wouldn't want people to have to visit him, that he wouldn't want people to have to see him, and he wouldn't want that for himself, especially being under the age of 30 and certainly having a life expectancy of, 50, 60 years or whatever, right? So what happens is the parents get rushed to the hospital. They are told by the doctors that there is no hope and that their recommendation is to let him pass peacefully, which is what he wanted, which he made very clear by his actions and what he was trying to indicate. Unfortunately, they panicked. They didn't want to believe that that was the case. They didn't want in their heart to believe that he wouldn't live a life and that he wouldn't be able to get up and that he wouldn't be able to communicate and that he couldn't be the son or daughter that they always knew and that they were there with and that they lived with for the past, his whole entire life. So they made the decision to introduce heroic and life-saving treatments. The doctors were very clear that that could be a risky proposition because once you introduce it, a lot of times it does give the body enough that it can sustain itself, but that it isn't going to be something that is going to allow him at any point in his life to live a life where he can communicate and understand. He will always be vegetative comatose. He will never come out of that. And what ended up happening was they ended up leaving him on it for, I believe, 2 to 3 weeks. And then the family met and they all talked and they all agreed that he would not want that. And he was very clear about his wishes. He was very clear about that is not something that he would want to occur. And they went ahead and made the very difficult and, just tough decision to withdraw treatment. Now, here's the problem. The emotional toll having to verbalize to withdraw treatment is so difficult. I can't even put into words the emotional trauma and stress that it put on that family, particularly the mother, who I remember just being so distraught about having to make that decision. Well, they did withdraw treatment, but he didn't pass away. the body was strong enough at that point to sustain itself. And here we are now, 15 years later, and he is still vegetative comatose. He's still not able to communicate. He is still not able to understand. He is still not able to get out of that bed. He will now live in a vegetative comatose situation for probably another 60 years or 50 years, which is difficult, not only for the family having to visit and see it, but also on the healthcare system where, you're talking $15,000 a month for the care that he's receiving. And certainly a young person could not afford that. So it is just a very difficult situation all around. I have talked to the parents. I have talked to the family, and they regret the decision. But in that moment, what I was told was that because it wasn't in writing, they just wanted to make sure. They just didn't want to take away a chance. They didn't want to take away a glimmer of hope. And had it been in writing, and had they known his wishes in writing, now, I think it would have been difficult no matter what. But at least if it was in writing, the doctors would have pushed it. The doctors would have said these are his wishes, and we would have probably ended up in a very different situation. But because it wasn't, it left that little bit of a situation where there was an argument, and they went ahead and just gave the heroic and life-saving treatment. So please, everybody over 18, make your wishes known. Make your financial wishes known, your medical wishes known. Make sure you have HIPAA language in the document, and also make sure that you have a living will so that we know if you're vegetative comatose, permanently unconscious, terminally ill, whether you would want, if two doctors say there's no realistic hope, would you want the introduction of heroic and life-saving measures? Sounds very basic, sounds pretty simple, but the power and what it does cannot be understated. And you will be doing your entire family a great service. We had another situation where a kid was off at college, drank too much, and was in the hospital and had to get his stomach pumped, and all kinds of medical issues that occurred from that and other things. And they were in a different state, and it ended up having to go to a guardianship hearing in order to have the parents appointed. And of course, that process takes a while. They did get an emergency guardianship to be able to make decisions in the short term, but then they had to go back into court, full-fledged hearing, 2 attorneys, one for the parents, one for the alleged incapacitated, as well as doctors testifying. Just horrific and horrible just time, and very, very difficult. And I cannot tell you how many times the parents have said to me since, man, we wish we would have listened. Man, we wish we would have had that in place. It would have saved so much heartache. And I could go on for story after story about parents who maybe they are paying the tuition bill, who maybe they are, maybe the child is on their health insurance, right? That by itself, they're an adult. They still cannot have someone making decisions for themselves, where parents who had their kids on their health insurance, parents who were paying the tuition bill, could not assist, could not make decisions for the child. So I implore you, please make sure that your children get those documents in place. Anybody over the age of 18 should have it in place. And I'm going to go one step further. Be very, very, very careful using online do-it-yourself documents. Sure, they're probably better than nothing. But the problem is almost none of them are state-specific. Every state in the country has specific rules as it relates to financial powers, medical powers, particularly financial powers and requirements for notaries, for notice, for acknowledgement, for all kinds of things, for what has to be in the document. And because they're all different, it's very difficult for online do-it-yourself systems, unless it is done by an attorney and it's specific to that state, to ensure that it has all the proper stuff. So please take the time, get the advice, get it done in the state that you live in so that you are sure that it meets the rules and it complies. And then even if they travel to different states, it would still be a valid document, and would still be able to be used in the event that someone in your life has a situation where they need you or someone else to make decisions for them, both financially and medically. So please, anyone over 18, take the time, get yourself registered to vote. If you're male, there's very few exceptions, but you do have to register for the military and make sure that you are filing for the selective service, getting those documents in place so that others can manage your money, manage your healthcare decisions, and also get registered to vote. It is a right that we have because of people who have fought for our freedoms, and I cannot understate the importance. So go ahead and take care of all those civic duties. Now, you still can't drink and you probably can't rent a car, but still important to make sure that all that other stuff is in place. I want to thank you. Thank you for joining me on the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo. On today's episode, we talked a lot about what it means to turn 18 and how you are presumed to be an adult. And that means that others cannot make decisions for you. You have to get a financial power, a medical power, and a living will in place so that your wishes and who you want to make decisions for you is very clearly written, so that if you are in the workforce, if you're in the military and you're overseas, others have the ability to continue to pay bills, make decisions, and particularly healthcare decisions for you if you can't make it for yourself. Don't forget, get yourself registered. If you're male, with very few exceptions, you're going to want to make sure you register for selective services for the military and get all of that in place sooner rather than later, so that in case something happens, you are taken care of. I can't thank you enough. If you need any assistance, please contact us at 717-845-5390 or check us out on the web at www.bellomoassociates.com. I want to thank you for joining us on the Red Wagon Estate Planning and Elder Law Show. Until next time, we'll see you real soon.